Clarke received her JD from Columbia Law School and her BA from Harvard. Assistant Attorney General Clarke, you are recognized for 5 minutes.
Chairman Cohen, Ranking Member Johnson, and members of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties. My name is Kristen Clarke, and I serve as Assistant Attorney General for the Civil Rights Division of the U.S. Department of Justice. And I want to thank you for the opportunity to testify today on the department's work to implement and enforce the Voting Rights Act of 1965 and the need to revitalize and restore the act. The Voting Rights Act is, as President Johnson said, one of the most monumental laws in the entire history of American freedom. It is a law that has helped to truly transform American democracy. However, the progress that we have made is fragile as we watch the current resurgence in attacks on voting rights. We have seen cuts to early voting periods, new and burdensome restrictions to register or vote, racially gerrymandered redistricting plans, polling sites eliminated or consolidated in communities of color, eligible voters purged from the rolls, restrictions on civic groups seeking to help voters participate in the process, and more. I am here today to sound an alarm. In 2013, the Supreme Court's decision in Shelby County versus Holder suspended the preclearance process, the Justice Department's single most powerful and effective tool for protecting the right to vote. The department's ability to protect the right to vote has been eroded as a result. For the Justice Department, restoration of the Voting Rights Act is a matter of great urgency. Before Shelby County, the preclearance process enabled the department to swiftly review and block the implementation of discriminatory and unconstitutional voting practices in covered jurisdictions. While Section 5 was in place, the Justice Department blocked over 3,000 voting changes, helping to protect the rights of millions of citizens. Evidence of discriminatory purpose, intentional discrimination, was found in over 60% of voting changes blocked by Section 5. In addition to blocking discrimination, the deterrent effect of the preclearance requirement was undeniable. The Shelby County ruling has given a green light to jurisdictions to now adopt voting restrictions. Today, these laws can only be challenged through long, protracted, resource-intensive, case-by-case litigation. The department knows well the burden that comes with the case-by-case approach by way of cases that we've brought recently in states like Texas and North Carolina. This gives to jurisdictions what the Supreme Court memorably called, quote, the advantage of time and inertia. Before Shelby County, jurisdictions had to meet their burden of proof by demonstrating that these rules were not adopted with a discriminatory purpose or would not worsen the position of minority voters. Today, discriminatory laws are allowed to take root immediately, impacting voters and corrupting the electoral process. We are on the cusp of another potentially transformational moment. Redistricting is about to commence. Virtually every jurisdiction that elects its members from districts, from state legislatures to county commissions, school boards, and town councils will be required to redraw district boundaries. New 2020 census numbers show the U.S. has become an increasingly diverse nation, with population growth attributable to increases in the number of people of color. Absent congressional action, this redistricting cycle will be the first without the full protections of the Voting Rights Act. Without preclearance, the Justice Department will not have access to maps and other redistricting-related information for many jurisdictions where there is reason for concern, even though this kind of information is necessary to assess where voting rights are being restricted and to help inform how the department directs its limited enforcement resources. In 1965, Congress enacted, and in 1975, 1982, and 2006, reauthorized a statute that provided the strong medicine needed to remedy voting discrimination and enforce our Constitution's commitment to ensuring that no citizen's right to vote would be abridged on account of race or color. Congress has broad enforcement powers and must act now to restore the Voting Rights Act to prevent us from backsliding into a nation where millions of citizens, particularly citizens of color, find it difficult to register, cast their ballot, and elect candidates of choice. We look forward to working with this Congress to revive this bedrock civil rights law. The Justice Department stands ready to support Congress in protecting the voting rights of all eligible Americans. Thank you.
And thank you. We appreciate it. We will now start questioning, and I will begin as is customary, and I'll recognize myself for 5 minutes. Ms. Clarke, why is Section 5 preclearance so crucial to combating discriminatory voting practices? And do you see a connection between the Supreme Court's decision in Shelby County v. Holder and the sustained attack on voting rights that we've seen since that decision over the past 8 years?
Thank you, Chairman Cohen. Section 5 of the Voting Rights Act was truly the heart of the act. This is a bedrock provision that provided a unique tool to deal with the problem of voting discrimination. In the course of our Section 5 preclearance process at the Justice Department, we were able to block over 3,000 discriminatory voting changes that would have otherwise have taken root. This prophylactic remedy is without parallel, and Section 2 of the Voting Rights Act is no substitute for the important protections that have been provided through the preclearance process. So we have lost something. And Chairman Cohen, since the court's ruling in 2013, we have seen states move swiftly to reinstitute discriminatory changes. We saw it on the day that the court issued its ruling in Texas when it moved forward with a discriminatory voter ID law that had been previously blocked by Section 5. We saw it in North Carolina when the state moved forward with an omnibus bill that turned the clock back on voting rights in multiple respects, and in a form in which the Fourth Circuit ultimately described as being carried out with almost surgical precision. So we have lost something, and this matter before Congress is an urgent one. We need the Section 5 preclearance process back in full force and effect. Without it, the Justice Department has lost its most important tool for safeguarding voting rights in our country. Thank you,
General Clarke. The Section 5 stands out. I would rate it, if you had to go on a scale of 1 to 10 of importance, it's a 9. And Section 2 may be a 2. But Section 2 was also damaged in the Brnovich versus Democratic National Committee ruling that denied litigation. It was a vote on denial litigation alleging vote denial claims, and it remains to be seen how that will affect Section 2 in general. The consensus for many of our prior witnesses who we've had in prior hearings is that it will make it more difficult to bring such claims. Do you agree with this assessment that Section 2 has been damaged in its ability to bring claims in the future?
Thank you, Chairman. The Justice Department is continuing to look closely at the Brnovich ruling. We observed that the last time that Congress amended Section 2 was in 1982. And it may be helpful for Congress to use this moment to clarify the factors that litigants should use to establish a Section 2 claim, the factors that courts should rely upon. Section 2 remains a very important tool that applies nationwide, as you observe, for confronting voting discrimination. And we urge Congress to think about ways in which to clarify how Section 2 should be applied by courts and by litigants.
Let me ask you this at that point. The guideposts that were announced by the court of Brnovich, and they did announce some, had no textual basis and were contrary to the intent of the 82 amendments to Section 2 that you mentioned of the Voting Rights Act, which Congress passed to ensure that the act eliminated discriminatory voting practices in all their forms. What approach would you suggest Congress take to clarify the scope of Section 2 now that the Brnovich decision has been issued?
Chairman, the Justice Department recognizes that that choice is ultimately one for Congress to make, but we would urge Congress to look closely at the ruling in Brnovich, to look at the ways in which factors identified the court may run contrary to the factors that Congress intended courts to consider when evaluating Section 2 claims. We have decades of case law interpreting Section 2. And so this may be one moment where Congress seizes the moment to make clear those factors that it wants courts to look at, and to clarify any confusion or gray area that may have resulted from the Brnovich ruling.
Thank you, General Clarke. Some have said this is a federal takeover of the state's authority to regulate elections. Would the changes, Alabama used to say you'd count the number of beans in a jar, or you had to repeat the Shakespeare or something like that before you could get a right to vote. Would those have been challenging those of federal takeover, quote unquote, of election laws, or would that simply been preserving voting rights?
The latter, Chairman, and I will say from the Justice Department's long experience implementing Section 5, that the department has always worked cooperatively with jurisdictions. It reviewed changes swiftly. At the most, it took 60 days to review and come up with a determination. There have been states that have made plain their view that participating in the Section 5 preclearance process was one that they were able to carry out with ease. So we don't deem this a federal takeover. We deem this a way of complementing Congress's considered judgment that we need the Voting Rights Act to ferret out discrimination and unconstitutional practices that may otherwise infect the electoral process in our country.
Thank you, Ms. Clarke, and my time is over. And I now yield to the ranking member